Alex here with a legal nuts and bolts video. The topic is going to be oppositions. So if you haven't seen my video on motions, please go back and watch that video now. Just pause this video and come back to it. So I'm going to assume that you've either seen my motion video or you paused it and went and looked at it right now. Everything that I've said in that video applies to oppositions. Everything down to the formatting, whether or not you're going to use forms, affidavits, certificates of service, all of that, the way you format it with the factual background and the legal analysis, that all needs to apply to the opposition. There's only two differences. The first is the caption. The caption for the previous paper, which is a motion, would be something along the lines of motion to modify child support, for example. The caption in your opposition needs to be opposition to, and then the exact name of what you're opposing. So if your opponent filed a motion to modify child support, then your opposition would be captioned opposition to motion to modify child support. Inside of the opposition, it's absolutely critical that you understand two things. The first thing is you need to address each assertion in your opponent's motion. Go down the list of everything that your opponent has asserted in their motion, and you have to oppose it in your opposition. If you skip over something, the court can assume that the thing that you skipped over, that you're conceding that. So if they brought up 3 issues and you only talk about 2 in your opposition, the court can assume that you don't mind the 3rd issue, that you don't oppose it, that issue is meritorious, and that's why you haven't gone over it. So it's important that you identify each specific request your opponent is making and that you oppose it if you really actually intend to oppose it. If you don't care, then you can just skip over it. But if you're opposing it, you have to assert in your opposition both the facts that support your opposition. So basically, they have a list of facts that supports what they're asking for. You would bring up your list of facts that flies in the face of what they're saying. And the legal, sometimes there'll be legal, well, sometimes you'll be able to attack their legal assertions. You can say that they're wrong, they've cited the wrong statute or the wrong rule, or it doesn't apply. Sometimes you can find new legal assertions that trump theirs. So, I mean, the point is that you're opposing their facts with your facts and their law with your law. That's the point of what I'm trying to make for your opposition. There's one extra thing. Some areas will allow you to file something called a counter motion with your opposition. In some areas will specifically say you can't do it. For example, in Washoe County, there's a court rule that specifically says you cannot combine a opposition with a motion. It's forbidden. But in other places, like in Clark County, there's areas of the areas in the court rules that actually talk about how you can go about filing a counter motion with your opposition. If you do that, you basically it's basically 2 papers in one. So your opposition, I think you should keep it separate, not tangle it up, but some people tangle it all up and it can get a little bit hairy when you do it that way. Just understand that you're still going to have to oppose everything that they've asserted, and on top of that, you're going to have to you're going to have to ask for all of the additional separate things that you want the court to give you. In Washoe County, which is where I had my child custody case, counter motions weren't allowed, and it wasn't a big deal because if I had to do that, I would file my opposition, and at the same time, I'd file a motion, and they'd be 2 separate papers. I mean, to me, that makes more sense, but some states allow a counter motion, and so I just wanted to bring up to look into that. If you really want to use it, you can. If it's not allowed, don't worry about it. Just file a motion at the same time as you file your opposition when you go to the courthouse. Get them both in there, and just like that, you basically did your own version of a counter motion. It was just a separate stack of paper. So there's not really any other there's not really anything else I can say. If you've seen the motion video, everything in there applies, down to the fact that if you just put in there, I don't want you to give my opponent what they're asking for, and that's it, and you don't put any rules or statutes or authority, you're relying on the court's luck, just as I mentioned for the person filing the motion. You, with your opposition, you're relying on the kindness and the niceness of the court, because if something goes wrong and you lose, now you can't appeal it in Nevada because you didn't cite any specific statutes to back up what you were saying. You might be able to still appeal it, arguing that the law that they brought up was wrong. But if you had some kind of law that would have trumped theirs and you didn't bring that up, you've waived that now. So please take it seriously, if at all possible. Try not to rely on the niceness of the judge, and just put plain English in there without any kind of research, because unless it's a really, really, really mainstream issue, something that they just see all the time and they know, which you would be surprised how many things are quirky, especially if your opponent has an attorney. They can bring up a lot of really quirky issues that the court doesn't see that often, especially if that happens. And the judge is more prone to make a mistake, because if they don't see it often, they're not reading that law very often because it's not coming in front of them, and they're going to have a harder time helping you. So it's just better that you just do your own research and put it in your opposition, just to play it safe, because you never know, you may be right, and if things go south, at least you can appeal it now, because you've brought up a point that you can assert in the appellate court. Whereas the person who just was praying for the judge to be nice didn't bring up anything, and so now they're just going to be stuck with it. So I mentioned in my previous video that my next video will be the reply video, and in the reply video I'll cover sort of how the court will ultimately deal with the motion, opposition, and reply. Once they're all submitted, some of the options the court has, and some of the routes it might take after it reads the motion, opposition, and reply. So with that, I'll end this video.